Welcome back to this week's episode of The Emily Show. Today, we've got to talk about why Diddy's lawyers are big mad about that witness who I talked about in Quick Bits this week. If you missed the Monday show, you are missing quite a lot. And we've got to talk about this Young Thug plea. I went through a lot of the court hearing with you, talked about what it meant, and whether or not this 15-year term of probation is a trap. Can't wait to hear your thoughts. Let's get into today's episode. Welcome to The Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. Thank you to our sponsor, Green Chef. Again, the only way that I actually eat a well-rounded dinner, literally ever. What I love is that Green Chef is delivered right to the door. You can pick from a wide variety of menus every week. And if you need to skip a week or modify a week, it's incredibly easy to do. No matter what's going on in our busy weeks, we have meals that are easy to prepare and that we love. And there are nights that now our teen makes dinner because T can follow along with the instructions. So whether you are looking for plant-based options or more protein, Green Chef has got you covered. And if you're really not going to have time to get to the store, Green Chef can add in meats, breakfast items, smoothies, quick to create lunches, and more. Plus, it's time for the holiday flavors. So if you need all of your Thanksgiving shopping done for you, now is the time to check out Green Chef. So if you are ready to find out for yourself why Green Chef is the #1 meal kit for eating well, it is time to go to greenchef.com/EmilyBaker50. Why? Because if you use code EmilyBaker50, you will get 50% off your first box and 20% off your next 2 months. That's code EmilyBaker50 at greenchef.com/EmilyBaker50 for 50% off your first month and 20% off your next 2 months. Thank you for sponsoring Green Chef and keeping me well fed. Let's get back to today's episode. Well, first, we're going to be going to Georgia to talk about the YSL case because I can't imagine how you even address a jury about the fact that the jury went on like a little break again and then came back, and instead of all 7 of the defendants being in the courtroom, there's 2 left. And they don't really get told what happens to the other defendants. They're not told anything. They're just told you no longer need to consider the cases against list of defendants. And then the other 2 are still sitting in court. But as jurors, they're not even allowed to talk about the case with each other. So when they go on a break, they can't look at one another and go, what do you think's going on here? This jury has been seated since opening statements since November of last year. They're coming up on being in trial for a year. Granted, there have been some extensive breaks in the case due to a wide variety of things. They had to come back to trial when there was an entirely new judge and be like, new judge, who this? But I can't imagine how they're even keeping track of what the case is anymore. Opening statements were last year. That's wild to me. So they had opening statements a year ago, and that was after over 10 months of jury selection. So even though the YSL case really starts with the arrest in 2022, for the jurors, it started in January of 2023 with jury selection, and then November for opening statements through so many issues. So even though the jury has had extended breaks, they are still on jury duty, and now there are only 2 defendants left in court. If you, like this jury, have forgotten what this case is about, I'm going to give you a quick summary, and then we're going to break down some of the details from the plea deal and talk about why this plea deal might have gone down, because some of these terms of probation, we're going to pull up the document. We're going to go to some clips from what happened in court and break all of this down, because as to Jeffery Williams, aka Young Thug, the case is over for him and many of his co-defendants. But in May 2022 is when this indictment came down, an 88-page RICO indictment. That is the overarching racketeering statute for Georgia. Yes, there is a federal statute. The Georgia statute's different. I broke it down in another podcast episode about how the Georgia statute's different. It's a fairly broad statute. In this case, they are using it against YSL, the label, and saying that the label was operating as a criminal gang organization. And instead of using the gang charges or the gang allegations that they can use in Georgia, they decided to loop everybody in on RICO so that they could use, it seems, the incidents underlying those predicate acts against Jeffery Williams, aka Young Thug, because he is not accused in most of this of being a direct participant. He is accused of being part of the overarching organization and really the main part of the overarching organization. So 88-page RICO indictment, 26 total defendants. There are 55 separate charges in the indictment. Not all charges go to all defendants. As we get to the plea deal, we'll go through exactly what Young Thug was charged with and pled to at the end of it. But this is the case that has had breaks in the case because Young Thug's attorney, Brian Steele, got held in contempt. That was subsequently completely overturned by the court, as it should have been. It was an improper use of contempt by the previous judge. That previous judge was removed from the case by a third judge. All of that took like 2 months. There was a defendant who got stabbed while in custody and was recovering for a period of time. There was a in-court deputy in the pretrial phase that had gotten arrested for having an improper relationship with one of the multiple defendants while this case was ongoing pretrial, and allowing that defendant access to an iPad and a phone and was making phone calls on their behalf. And that aggravated things because then that investigation was ongoing. A different defense attorney was arrested coming into the courthouse, and on and on and on. So this case not only is a, how to say it kindly, unorganized and sprawling RICO prosecution, it has also been rife with issues. Oh, I forgot to mention the prosecutors have also had to go to like remedial Brady school for not turning over evidence. There's been issues with ex parte hearings with the judge and witnesses, and on and on. So this case has not been well organized. So when it's like, Emily, what's the RICO really about? It's like, well, it's a very large gang case and they're trying to push it into a RICO case. And it seems at times that the prosecution's not sure what the witnesses are going to say when they come into court or what witnesses are coming into court on a given day. It has not been a cleanly prosecuted case. And the current judge is really tired of it. I'm still shocked that this whole case hasn't ended in a mistrial. And that's what gets us to where we are today. And again, I record in advance. So we are recording on, Emily, did you have to check the date? Yes. We are recording on Monday, November 4th. So we are a couple days after Young Thug was released from custody on Halloween. But the pending mistrial is what led us to today. There was a looming mistrial, and the judge, it seemed, was amenable to granting a mistrial, but not amenable to granting a mistrial with prejudice. And so that would have meant that for all of these defendants, the case simply would have started over. Young Thug and many of his co-defendants, in fact, I think all, but I'm not 100% sure, are being held without the potential of bail. Some of the co-defendants are in custody on other cases, have been convicted and are serving time on other cases, so it's not as much of an issue for them. But for Jeffery Williams in particular, he is not serving time on any other cases, so he was in custody, no bail, only on this case. So if there had been a mistrial granted, then the case would have started all over again, keeping in mind that it took almost 11 months to pick a jury, and we are now almost a year into the case from when opening statements started November last year, and they're looking at another 3 or 4 months of trial at this go round. So I can understand how well a mistrial is looming. The defendants who were amenable to taking pleas were like, can we just be done? So a number of defendants took pleas. We're going to go over the plea deal for Young Thug because I've gotten a lot of questions about it. There are some questions about it. And it's a really unique situation where negotiations between the prosecution team and the defense attorneys broke down. That's not a surprise in this case to anyone who's been watching it, because the defense and the prosecution have not spared words for one another. But it's unique in a multi-count indictment that the defendant pled open to the court, essentially pleading blind to the sheet. I call it plead open because I practiced in California, and that's what it was regularly called there. I'm going to be explaining some of the language they use in Georgia that's different than language they use elsewhere in the country. But cases are jurisdiction by jurisdiction unless you're in federal court, and then it's a little bit different. So as we go through this, you're going to hear some language that might be unfamiliar. Don't worry, I'll break it down for you. We're going to go through what this plea deal is, where it's unique, the substantial amount of probation time. But I really think the reason that this deal was taken is because Young Thug was ready to get out of custody, and this was an opportunity to do so. And when plea negotiations broke down, he decided to try his hand with the judge. And it seems, based on statements Brian Steele has given to the media, that if they were able to go the distance with this trial, that they would be victorious at the end and Young Thug would be found not guilty. So it seemed that his attorney really didn't want him to take the plea deal. However, that is the client's decision. And when you're looking at another 4 months in custody versus getting out today, sometimes the getting out today is too tempting to ride it out for the long haul, even if that's what your attorney is advising. And based on those statements to the media, it seems that that's really how Brian Steele feels about it. He said that the prosecutor's conditions were absolutely outrageous. Quote, they would let him out of custody, but they would have had a tether around him so tight that it's unconscionable. And that's why Young Thug went forward with the plea to the judge. But that means it is an open plea to the court, and then the court gets to decide. There's no deal on the table. He doesn't know what he's getting. What I think is really interesting is that the prosecution was willing to let him out of custody. And then when he pled open to the court, we're asking for quite a substantial bit more time than they had been willing to negotiate because they wanted the conditions that they wanted. I still think some of these conditions are incredibly onerous. You're going to have to let me know what you think, but these terms of probation might be incredibly difficult. So now we're going to be getting into court to take a look at what went down when this plea deal got put on the record. So we're going to hear from the DA, we're going to hear from Young Thug, we're going to hear from the court, and then we're going to go through these terms of probation. But I will be jumping through parts of this court hearing because there were a lot of starts and stops. And for time, we are going to be jumping through some of those parts because the court is going to summarize it for us at the end when we get to the court's final sentence on this plea.
Notwithstanding the fact that this is a blind plea. You understand that, Mr. Williams? Okay.
So the state confirms with Jeffery Williams that this is a blind plea. That means it's an open plea to the court. He has no idea what the court is going to do. And then she confirms with him about the state's previous offer.
And Mr. Williams, were you aware of the state's previous offer that was turned down prior to your making this non-negotiated plea?
Yes.
All right. And Your Honor, at this time, the state is making a recommendation of 45 years with 25 to serve in custody, followed by 20 on probation.
So what the state is saying, and we will hear from Mr. Williams' attorney in a moment about what the previous offer is, but the state is offering 45 years with 25 served in custody. He's been in since 2022, that's it. 45 years, 25 served in custody, and then 20 years on probation. And then the state's going to get into those conditions. The previous offer had involved him getting out of custody immediately. So it's a big shift from the state to go from you can get out today to you need to serve 25 years. Just a very large shift in position from the state here.
Subject to the special requirements of 1615 for the gang statute.
All right, and do you want to break down for me what your recommended sentence on each count is?
Yes, Your Honor.
And then the state gets into breaking down how they get to, for each of the counts, that 45 years with 25 served, 25 probation. And the state breaks that down for the court. That's not what he's going to be sentenced to. So that's not what we're going to go through. We're going to go through the previous offer as it gets put on the record.
The state's previous offer was a total of 43 years with 20 years, 5 years to serve on count 56, commuted to time served, followed by 15 years on probation. On count 58, the sentence was 10 years to serve in the Georgia Department of Corrections, consecutive to count 56. Count 59 was 3 years to serve in the Georgia Department of Corrections, consecutive to counts 56 and 58. Count 60 was 5 years to serve in the Georgia Department of Corrections, consecutive to counts 56, 58, and 59. Count 61 was 5 years to serve in the Georgia Department of Corrections, consecutive to counts 56, 58, 59, and 60.
Was that the entirety of what the sentence was?
No, Your Honor,
I mean, I know
still
there were
reading.
special conditions,
You can hear the court being like, is that everything or is there more?
so y'all were
There
going
are-
to null pros,
We,
what,
yeah,
1
yeah.
and 62?
So what the court is clarifying here is that the prosecution was going to dismiss some of the counts. And so the court was like, is that the entirety of the deal? And the prosecutor said, no, we were going to null pros or dismiss 2 of the charges.
Yes, as part of the recommended sentence, in exchange for the defendant agreeing to the special conditions that we asked the court to impose, the state was willing to null pros count 1, count 57, and count 62.
Okay.
Count 1 is the RICO charge. Count 57 is the gang activity charge, participating in criminal street gang activity. And count 62 is a use of a machine gun charge. So some fairly serious charges. The prosecution was going to get rid of count 1, count 57, and count 62 as it went to Young Thug. But because the conditions were unacceptable to the defense, he's pleading open, which means there are pleas on those counts now entered into the record, but we'll get there.
Okay. And then all of that consecutive to the probation, that was going to be what we call backloaded. And what were y'all proposing with regard to that, since it was to follow the probated sentence?
The total sentence was 43 years to serve, with the first 5 years in prison commuted to time served, followed by 15 years on probation, followed by 23 years in prison, which would have been served in confinement, except that if defendant had complied with the special conditions of probation imposed as part of this sentence, the backloaded portion of defendant's sentence would have been commuted. However, should defendant had violated any special condition of probation within the first 15 years of his sentence, his probated sentence would have immediately been revoked, and he would have been required to serve the entire remainder of his sentence confined to the Georgia Department of Corrections.
So what that means is that the prosecution's original offer to the defense, well, not original, the offer as this was all going down last week, the offer to the defense was that his time in custody, it was 20 years with 5 years being served in custody. And that was being, they call it commuted, but that was being essentially converted to time served. So we're giving you 5 years. You've been in for 2.5, roughly probably a little bit more. So we're going to call that 5 years already served. Then you're going to do 15 years of probation. So you get out today, you have 15 years of probation with the conditions that the defense said no way to. Then what they call backloaded time is suspended time. So the suspended time or backloaded time of 23 years is hanging over that 15 years probation. If you violate probation, then you serve that 23 years of backloaded time. So the state was offering, you serve 5 years, you've got time served, you get out today, 15 years probation plus that backloaded time. Really, that backloaded time means time that's waiting for you if you violate your probation. Probation violations do not run on a beyond the reasonable doubt standard. Probation violations can be much easier to prove. They run on a lower standard, and depending what the terms of probation are, it can be very tricky to navigate without violating probation. If he had violated probation on any of the state's terms that he did not accept, then that 23 years is essentially imposed, and you get violated on probation, and then you serve those 23 years starting fresh.
Right. So as long as he had successfully completed his 15 years of probation, the 23 years that was going to follow it was going to be commuted to time served as long as his probation was successful. Is that right?
Yes, Your Honor.
Okay.
And the special, would the court like for us to?
No, I was really more interested in the length of sentence and what y'all had. I mean, I know you didn't reach agreement, but y'all, that's what the last offer had been with, of course, a bunch of special conditions, which I guess is where the hang-up is. I don't know.
Right. Defendant did not want to agree to the special conditions.
All right. Is that basically your understanding too, Mr.
Yes, Your
Steele
Honor. It
and
would
Mr.
have been,
Adams?
yes, Your Honor. Mr. Williams would have been released today for 15 years on probation. If he successfully completes that probation, then he would not have to go to custody. If he did not, he'd face probation revocation as well as 23 years, as the court said, backloaded in the Georgia prison system. But we could not come to terms on all the conditions that the district attorney was insisting upon.
Okay. All right. Thank you. Go ahead, Ms. Love.
And that was defense attorney Brian Steele saying, no, we could not come to agreement on the conditions that the district attorney wanted. The prosecution advised Jeffery Williams, aka Young Thug, of all of his rights, including if you choose not to take a plea today, your trial will just continue as it's been going. So you will just go back to trial. But now she is inquiring if he understands all those rights and wants to plead guilty. And this is where his defense attorney is going to jump in to talk about whether or not he will be able to plea nolo contendere instead of guilty. And we're going to hear from the defense attorney, Mr. Steele, to the court about that right now.
Waive these rights and enter a guilty plea because you are in fact guilty.
Yes. Well, Your Honor, may I interject?
You may.
Your Honor, on count 1, which is the racketeering conspiracy count, Mr. Williams is tendering a plea under nolo contendere. As to count 56, which is participation in a criminal street gang activity as being a leader or a supervisor or organizer, Mr. Williams is also tendering a plea to this honorable court as under nolo contendere. The balance of the counts, so he is tendering a guilty plea.
Your Honor,
Yes, ma'am.
would the court like to hear from the state or not?
About the NOLO issues?
Yes. Yes.
Sure.
Your Honor, the state,
Because this is not an agreed upon plea disposition, the state is like, no, if you are pleading open to the court, then you are pleading open to the court. And those are going to be guilty pleas, not nolo pleas. Nolo pleas are saying, I am taking a plea, but I am not accepting guilt. So if there were civil lawsuits or anything else, that wouldn't come up. So the state is going to argue against this point with Brian Steele asking to allow for those first 2 counts, the RICO conspiracy and the gang organization count in count 56, to plead those nolo. And we're going to hear what the state has to say about that.
ask that the court not accept a nolo plea and require either a guilty plea or a not guilty plea as to these charges.
All right. I'm going to permit a NOLO plea as to count.
If you are listening on audio, you cannot see the court's face as the court looks at the prosecutor in this, but the prosecutor said, I would like the court to require a guilty or not guilty plea, not a no-low plea. And the court goes, all right, I'm going to allow it. Like immediately, the court's like, yeah, no, we're going to allow this to go forward. Since all the waivers have been given and the court has decided that she will allow the defendant to plead nolo contendere to 2 of the counts, the prosecutor is now going to take the pleas. Again, for me, this is an open plea to the court. I'm surprised the court is not taking these pleas because the prosecutor at this point is out of the process. The prosecutor can't stop this process. The prosecutor can object to the sentence, can tell the court what they think sentencing should be, but the defendant has the right to say, you know what, I'm going to plead to all these counts, and this is between me and the judge now. This has nothing to do with the prosecutor at this point. So I am surprised that the judge is not the one taking these pleas, but we're going to hear the prosecutor take these pleas now.
As to count 57, participation in criminal street gang activity, how do you plead?
I plead guilty.
As to count 58, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 59, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 60, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 61, possession of a firearm during the commission of a felony, how do you plead?
Guilty.
And as to count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, how do you plead?
No law.
As to count 56, participation in criminal street gang activity under the leadership charge, how do you plead?
No law.
I think you didn't ask about count 62.
As to count, thank you, Your Honor. As to count 62, possession of a machine gun, how do you plead?
Guilty.
And for those of you listening on audio, the defense attorney continues to just wipe his face with his hand because there is nothing he can do to stop this from happening. But it is clear he is not happy. But again, this is his client's decision. His client is the one in custody. His client is the one that is now facing either doing this all over again, doing this for another 3 months, or taking a deal and getting out today. And now that the guilty plea is in, the prosecutor and the court a bit advised the defendant of his further rights, made sure that the plea was voluntarily given, and is now asking the court for more, even though she had already asked the court for that 45-year sentence with 25 served in custody and 20 years of probation. So let's hear what else the prosecution would like.
The time periods.
And Your Honor, the state, in addition to the sentence we are asking that the court to impose,
Okay.
we would also be asking the court to require or to forfeit, have defendant forfeit all of the property that has been seized and that is currently being held, that was found or recovered or taken from his home after it was searched on May 9th.
Do you have any kind of list of what that property is? I mean, I'm not familiar with what was seized.
And Your Honor, we're not
do,
agreeing.
and that-
Oh, I mean, I assume y'all aren't agreeing to anything.
We're not
You
agreeing
would
to that.
present it as a negotiated plea.
We're not, but we do have a list of the
All right.
property
Do you have
items.
it where available right now?
Yes, actually, would the court permit us to send it electronically?
Sure,
Because we
that's fine. And then if that is not imposed as a condition, is it just get litigated as like any forfeiture matter?
Yeah, it's
Yeah,
a-
it would be litigated later on,
It's a
yes.
civil separate.
In quite a lot of actions, criminal actions, particularly RICO actions, conspiracy actions, and what have you, there are often forfeiture provisions. This is common in drug cases, gang cases. It just depends if an amount of money and property is recovered and they're saying it's part of the gang organization. And here they are saying that the record label is the organization, so anything connected to that can be forfeited. The court is saying, do you have the list of property? And the prosecutor's like, can we email it to you? The defense is like, I'm not agreeing to any of that. And the court said, so if it's not imposed, and I think the court knows where she's going with this already, if it's not imposed, then what happens? And then it goes to a full civil forfeiture hearing. So it becomes a separate process versus the forfeiture just being granted. Oftentimes when there are plea deals in federal criminal cases, the forfeiture amount, money seized or property seized or what have you, will generally be agreed to as part of the agreement. But this is an open plea to the court. And I don't think this court is very thrilled with this case at all. So I think the court knows what she's going to do with that. The prosecutor also asked for gang conditions that are in keeping with the statute in Georgia, and the court is going to chime in on this now, which gives us a little bit of insight into what some of the problems were in negotiation.
The rest of that into the record if the court requires, or I can continue with the factual basis.
All right, and let me ask you, because I know that at least while y'all were negotiating, one of the things that I guess was being negotiated was some exception for, I think, somebody that is contractually obligated on his record label. Is that something that the state would still be in agreement to?
No, Your Honor.
Okay.
So with gang conditions in most probationary settings, there is a blanket stay away from all known gang members. The court said one of the things y'all were negotiating was somebody who's contractually obligated to the record label. I'm assuming that that indicates that that person may be a known gang member. I don't know if that's one of the co-defendants. And the court is saying you guys were trying to negotiate that. Is the state still in agreement? And the prosecutor's like, no. However, this, when you're using the RICO statute for a record label, there are going to be some really difficult aspects of probation that are unique to this defendant. But if the defendant is going to be let out of jail on conditions, those have to be conditions that he has a chance at succeeding at. Otherwise, it should just be custody time. If the conditions are structured so that there is not even a reasonable possibility of success, then it shouldn't be probation. It should just be custody time. As they are still going back and forth on the record about who he can and can't communicate with, who he is allowed to have communications with, we're starting to get into how defense attorney Brian Steele feels about this plea deal and about this case, and a lot about what he wants to communicate to the court about this case. So we are jumping in to him talking about that on the record with the court as he's making his record about what some of these terms and conditions of probation should be.
Okay, that's Mr. Williams' phone. This is how the trial has gone for us. But we sit here for almost 2 years since we did our jury selection initiation on January 4th, 2023. Mr. Williams has been sitting in a jail since May 9th, 2022. This is 2.5 years waiting for the conclusion of the state's case and a verdict from the jury, and that's why he is tendering this plea. I'm telling the court this, and the court knows when you came out the first time, it's very hard for Mr. Williams. I am not supportive of what we're doing right now. I'm not against it. But I told Mr. Williams, you okay with me saying this? Yes. I told Mr.
You
Williams.
hear Mr. Steele look at his client and say, are you okay with me saying it? Because there is a level of attorney-client privilege, but Brian Steele, if you're going to say anything about Brian Steele, the first thing you're going to probably say about this attorney is he is incredibly passionate in how he does his work. And so he doesn't want to run away with talking really outside of what he's allowed to share. But he's also saying, Your Honor, I am not supportive of what we're doing here. He's like, I'm not saying we shouldn't do the plea deal. My client wants to do it, but he's making clear my client wants this. This is incredibly difficult for him, and this is why. So he's sharing with the court part of the decision-making process here so the court understands why he's willing to take this plea deal when Brian Steele clearly thinks that when they ever get to the end of this case, that he would probably be acquitted. And that's what Brian Steele clearly believes. So let's hear the rest of what he has to say about his conversations with his client and why this is happening.
That I think we're winning the trial and we should go to verdict. But he told me I can't wait another 3 months if there is any possibility I could go home because I have children that are hurting. I have things to do, and he has some medical issues that he would like to tend to. He eats out of a bag, Your Honor. He eats processed food only. He gained 75 pounds during trial. He's lost it since. But it is hard. You know, for me, it's only 3 more months. It's enjoyable, actually. I enjoy coming. It's not that enjoyable for Mr. Williams. He told me he wakes up. Can I say?
Yes.
He wakes up every day, and it's another day in HE blank blank. Your Honor, the state is talking about.
So there we get a glimpse of the decision-making process, because I'm sure there are going to be many asking, if he thinks he's winning the trial, why in the world is he taking this deal? And he doesn't know what the court is going to do. He knows that the state's asking for him to serve 25 years in custody to start with. So why take the plea deal? And that's what his attorney was saying. He doesn't want to wait another 3 months. He wants to be out of custody. He's not going to get out of custody. He doesn't want to wake up at 3 a.m. with, the attorney said, itchy blank blank. He doesn't want to be in custody any longer. And that is the overriding decision here. It doesn't matter how long he's on probation for, some of the terms he couldn't deal with, but if there's any possibility he's getting out, then that's exactly what he wants to do. And I'm sure his attorney said, you're going to have to be incredibly careful, because the state is going to continue looking at you while you are on probation and looking at you closely. And now we're going to hear what Brian Steele thinks this case is worth, and his frustration with the prosecutor drastically shifting what they're asking for in the same day.
But the point I'm trying to make is 45 years to serve 25 years in prison, when just this morning it was a probationary offer. It was a probationary offer. The state knows, but they want to control. They have this theory of music, and they want to stop Mr. Williams from making music, from entertaining, just stop his life. That's just not right. And it's wrong of the district attorney in Fulton County to do that. If they offer probation, then he's not a 45 to serve 25 years in custody type of person, and he's certainly not the person that the state has stated in front of the court. What we're asking, Your Honor, on count one, which...
And this is what the defense is asking the court for, and we will see what she does shortly.
...is the RICO count to accept the nolo contendere plea. Please sentence Mr. Williams to 20 years to serve 5 years in prison commuted to time served. Mr. Williams has served, as I said, 22.5 years. On count 56, Your Honor, that's the leadership of a gang, nolo plea, 20 years to serve 5 years commuted to time served, consecutive to all other counts. On count 57, which is a gang count, Your Honor, not a leader, guilty plea, 20 years to serve 5 years commuted to time served, concurrent with count 1. With regard to count 58, which is possession of, I believe it is marijuana with intent to distribute, 10-year sentence on probation, concurrent with count 1. On count 59, which is violation of Georgia Controlled Substance Act, possession of codeine with intent to distribute, 5 years on probation, concurrent with count 1. On count 59, Your Honor, which is violation of Georgia Controlled Substance Act, possession of cocaine, 3 years on probation, concurrent with count 1. Count 61, 5 years of probation. It's a firearm count, consecutive to the other counts, consecutive to before count 56.
So consecutive meaning altogether.
And then count 62, 10 years to serve commuted to time served. That should be a total sentence, Your Honor, that we are respectfully requesting the court to consider. I believe it's 45 years to serve 5 years in prison, commuted to time served, 40 years on probation, credit for the time already served and commuted time served, as I said, after 3 years of probation.
He's asking for 40 years of probation. 45 years, 5 in custody with time served, 40 years on probation. That's what the defense is asking for. And then he's asking for a shift after 3 years of probation. So you're going to hear that now.
The probation becomes non-reporting, and after successful completion of 10 years on probation, the balance of the sentence be terminated.
So 3 years supervised probation, then 10 years of unsupervised probation. And when that is successfully completed, all of it terminated. So if he essentially does 3 years of supervised probation and then the unsupervised 10 years on probation, which is actually probably the balance is what he intends. So 7 years unsupervised. If that's successful, then terminate the entirety of the probation is what he's asking for. So an opportunity for only 10 years of probation with time served.
Mr. Williams asked the court for house arrest for 3 years as part of the sentence, but house arrest specifically defined that Mr. Williams will be in his home.
And he's offering 3 years of house arrest. I wonder if this is Brian Steele's way of trying to get around some of those probationary conditions.
Or at any lawful employment, touring, studio, performance, business meetings, and the like. Wear an ankle monitor for the first year and pay the costs of same. And the company must be approved by probation department. And the ankle monitor to be affixed within 10 days of hopeful release from custody. Mr. Williams cannot possess a firearm, but he can be around licensed security who are armed or other persons who are lawfully carrying a firearm with their license. And that would be knowingly for Mr. Williams. Mr. Williams can transfer probation outside the state of Georgia. He has residences in the state of California. He has studios in the state of California. Mr. Williams be allowed to travel throughout our country and the world for lawful work-related industries. Mr. Williams wants to perform. He's going to do this anyway, Your Honor, but we made it part of the sentence. At least one concert each year at a venue, if they'll have him holding 10,000 people, if that is workable for the venue and Mr. Williams' management, and he is going to donate all of the profits that he makes to a 501c3 charity. Mr. Williams wants to pledge $100,000 for the next 3 years to the Fulton County Sheriff's Office if they will hold.
He's also pledging $300,000 to the Sheriff's Department plus a benefit concert. These are the terms of probation that the defense is offering to the court.
An illegal firearm buyback to buy back firearms that are not supposed to be on our streets. Mr. Williams does not wish to go near the Cleveland Avenue area, not to insult that area at all, but it is just not a good idea under this circumstance.
It's not uncommon in gang cases that there will be a stay away from a certain area. We'll talk about what the court does with that in a minute, but he's saying, look, he agrees that he will stay away from this area and more.
And he can drive on the highway, but otherwise not come within 1 mile of the area that we call Cleveland Avenue, and we can give the exact dimensions of that area. Mr. Williams must perform 100 hours of community service per year for the next 3 years as designated by probation department.
It's a lot of community service. 300
Mr.
hours
Williams
over 3 years.
can associate, and this was agreed to previously, with people who are convicted felon or alleged gang members solely for lawful purpose of making music.
All right, I see Ms. Love shaking her head. And
So Brian Steele is saying, we've agreed that he can associate with convicted felons or gang members for the purpose of creating music. And the court chimes in and says, no, I see the prosecutor shaking her head. We know the prosecution doesn't agree to that, so we will continue. As the defense continues, they are talking about very common conditions of probation. And then we are going to get into what Mr. Williams has to say. A huge thank you to today's sponsor, Honeylove, not only for keeping me and the law nerds comfortable, but also for literally making my favorite pajamas in the world. And yes, you might know Honeylove for their shapewear and their bras, but don't sleep on the pajamas. They are my favorite. So whether you are getting ready for the holiday season or just want to feel smoother for the sweater weather, Honeylove has got you covered. One of the things I hate when I want to feel sleek in what I am wearing is that bra bulge in the back, and Honeylove's bras are designed with back smoothing fabric to prevent that uncomfortable back bulge. Check out their V-neck bra for a totally smooth fit under clothing, and it offers support without the uncomfortable underwire. Honeylove's molded cups are designed to fit. It is time to take your comfort level up a little bit with Honeylove. And right now, we've got an incredible deal for you. Treat yourself to the best bras, shapewear, and I say sleepwear on the market and save up to 50% site-wide. Yes, you heard me right, 50% site-wide at honeylove.com/lawnerd. But that deal is this month only. Inventory is limited and the sale ends soon, so don't miss their best deals of the year. And if they ask you where you heard about them, please let them know it was from the Emily Show. Elevate your comfort, elevate your style. Thanks to today's sponsor, Honeylove. Let's get back to today's show.
All right, Mr. Williams, is there anything that you want to say?
Yes, ma'am. I take full responsibility for, my crimes or my charges. I want to say sorry to my family, my mom. My mom got 11 kids. I can't say all their names, my managers, my kids that's not here. Really everybody that got something to do with this situation, I want to say sorry for just having so much time invested into this, and I am a smart guy, I am a good guy, and I really got a good heart, I find myself in a lot of stuff because I was just nice or cool, and I understand that you can't be that way when you reach a certain height because it could end bad, and it don't really have to have nothing to do with you, but it could end bad and it could, fall on you. And I know the choice is yours, it's up to you, and I hope that you allow me to go home today and just trust in me to just do the right thing and never see you again unless it's at a bar in the future or something. Just out of this type of situation, I promise you I won't.
Yes, that was him saying, Your Honor, I don't want to see you again. I mean, unless it's at a bar or something, but not in this situation. I don't want to be back in court ever. I don't doubt that what he's saying is 100 on that. He's like, I don't ever want to be back here again. And as he's talking about learning that if you are associating with people who are up to the things that are charged in this RICO case, that it can come back on you, I think that's something that's hard for people to wrap their mind around with some of the gang charges and the way those work, but also with RICO charges and the way they work, even with conspiracy charges and the way they work, that yes, if you are being charged as part of the organization, then the things other people do start to be leveraged against you. And aiding and abetting is the same thing. There are a lot of areas in the law where just because you didn't maybe do the thing, it doesn't mean that you're not responsible for a thing. And I don't doubt that continues to be eye-opening, because in the way we've seen RICO used in the past with music labels, it's been used more like it is in Diddy and R. Kelly and elsewhere, not in what is more traditionally prosecuted under gang statutes. So this, I'm sure, has been eye-opening, and you can hear some chuckles in the courtroom as he's maybe offering to buy the judge a drink, but trying to say, it's not, I don't have anything against you, Your Honor. I don't want to be back in court ever. So let's finish hearing what Mr. Williams has to say.
I'll ever be in this type of situation again. I'm going away. I've learned from my mistakes. You know, I come from nothing and I've made something and I didn't take full advantage of it. I'm sorry. Through these last 2.5 years of my life, you are really, truly, honestly, the best thing that has happened to me because you made everything fair for me and everybody involved on both sides, you know. I'm sorry to the sheriff, you know, everybody for just having to put extra time in. I know y'all got paid more money, but I'm sorry for y'all having to put this extra time in to be away from y'all family, you know, and I just hope that you find it in your heart to allow me to go home and be with my family and just do better as a person. I know what I bring to the table. I know what I am. I know the heights I've reached. I know the impact I got on people, period, in the community, you know, all people. I learned that late, like these past 2 or 3 years of my life, I kind of learned that late. And maybe it was because I was, you know, probably on drugs or anything, I don't know. But I have came to my senses and I understand what I mean to this world. But I am a good guy, you know, I don't mind doing stuff like, you know, like free shows, and I always did that. You know, I did free shows and gave it to single parents, millions of dollars. You know, I made $1.8 million on a free show, and I gave it all to single parent charity. And I did like 2 or 3 shows that made like $700,000 a piece, and I gave it to the breast cancer organization. Like, you know, I do things like I put millions of dollars back into my community for real. I really did. I did more than anybody ever did from my side, you know. But I understand, you know, rap lyrics. I understand how it could be twisted. I understand what it could do to the mind of people. I understand all that, and I promise you I'm 100% changing that. You know, it's just, I'm older, I'm grown now, you know, and it's just like, I'm smarter. It's more things to rap about. Like, I've experienced a lot of good things. I experienced more bad things, but I experienced a lot of good things too. And anyway, I can go forever.
Well, I appreciate it. And I appreciate that you do realize how much of an impact you have on people.
Before we get into the rest of the judge's statements, I think one of the things that was really interesting about his statement was telling the court you are really in the last few years the best thing that has happened because you made it fair. There was so much fighting with the past judge. I think he's not just trying to flatter the court. He's not just trying to say, Your Honor, you're the best judge. This case has really been wild. And so I think in everything that is incredibly genuine to say to the court, thank you. And I very much want to move forward. I want to help our community. And if that's true, the court is going to let him out with some onerous conditions, but he has the opportunity to meet those conditions, be out of custody, and stay out of custody. So let's hear the rest of what the court has to say.
I mean, it's past your neighborhood. It's worldwide, especially young people. And having come up from where you came up from and living in and around that, you know that gangs are damaging to our community. And it may be that a whole lot of rap music and the rap industry is, I mean, honestly, it sounds like a modern day version of kind of WWE wrestling that used to be on television, where people would just get up and posture and act like they hated each other. And it may be that that's a lot of what is going on in the music industry with rap.
Yeah, I do think the court just compared rap to the WWE. which I don't, again, I don't know where this judge sits. I don't know how many cases the judge sees. I'm sure some of all music is posturing, some of it is not. But also, I lived through the 90s on the West Coast. So when we talk about Keefe D and Tupac, what is said in songs can very much spark what happens in the street. And I think there's needs to be some acknowledgement of that as well. But the court is talking about, look, sometimes lyrics are just lyrics. And that's true too. Sometimes lyrics are just lyrics. But if those lyrics also spark action, then where is the balance between that? And where is the balance between what you can say in music and what can be used against you? The court ruling, and not this judge, the previous judge ruling that lyrics would come in this case was a huge turning point for this case and a controversial one, because where is music just music and where is it not? And where is the bounds of having to tie something to being linked to events versus taking something that is broader and saying, no, it means this. So the court, I didn't think she was going to get to a WWE analogy, but the court is really saying how much of this is just bluster. I'm interested to see what else she has to say.
But whether it is fake or not, it has tremendous impact on kids and young people who think, this is cool, this is what I want to do. Look at him, he's a millionaire. I can do that by being, a gangster in the streets. And that's not true. What you're likely to have happen to you if you're a gangster in the streets is you get shot, you get killed, or you get thrown in prison. And those are...
I mean, the judge isn't wrong on that, because that's the reality of it. And he knows that. She knows that. And the other defendants sitting in court are also very well aware of that.
Are, by far the most likely outcomes. And, you've been in here watching the trial and you've seen the pictures of Mr. Ryan posing with a gun as big as he is at 15 years old and going out and shooting and killing another teenager. And that's what gangs do. And that's unfortunately a lot of what rap music does. And if you are a modern day John Lennon, he might have rapped too in this day and age. I don't know, but I know you're talented. And
we did get from the WWE to John Lennon. We're gonna keep going.
And even if you choose to continue to rap, you need to try to use your influence to let kids know that that is not the way to go, and that there are ways out of poverty besides hooking up with the powerful guy at the end of the street selling drugs. And, I know that happens for protection sometimes, but a much better way would be getting an education and setting, hanging around with people who set a good example. And you be one of those people that sets a good example.
And the court is starting to tread onto what you need to sing about. And that is going to be interesting as this case goes forward.
All right, so that's my high horse on that. I could also go on. But I want you to try to be more of the solution and less of the problem. All right.
And now we're going to get to what the court's sentence is. We're going to hear her pronounce it, and then we are going to move forward. And I'll pull up the documents and we'll go through the written out terms of probation. And you guys know that I record the podcast episode with the Law Nerd members from the Law Nerd Lounge and YouTube in the live chat. And chat has shared with me that in some of the comments that we moved through from Steele, he said that Elton John compared Young Thug to a modern day John Lennon. So it wasn't a reference out of the blue. It was a reference very much contained within the four corners of the courtroom here. So we're going to go forward into what the court pronounces as the sentence. So the court has gone through count by count and is now totaling up what the sentence is going to be and then get into the terms of probation.
Also backloaded. So essentially, the total sentence is 40 years to serve the first 5 years in prison, but commuted to the time that you have already served, followed by 15 years on probation, followed then by the backloaded 20 years, which can be served in custody and will be served in custody if you are not successful on your probation. If you are successful,
40 years total, 15 years on probation, and then that suspended sentence or backloaded sentence that if you violate probation, you just get sentenced to. There's no conversation about it. That backloaded time gets imposed. If you successfully complete probation, then that backloaded time or suspended time goes away. But that 5 years served was commuted or reduced to time served to allow him to be out of court the day that this happened on October 31st.
in completing your 15 years probation, that will be commuted to time served. You are to remain on reporting status for the first half of your probation, active reporting for the first 7.5 years of your probation, and that.
So the court then clarifies that the first 7.5 years of probation is reporting probation, checking in with probation officers, probably taking drug tests, letting probation know every time you go anywhere, move anywhere, what state you're going to be in, what work you're going to be doing, who you're going to be working with. Literally everything that you do is going to be checking in with probation, and they have the option to say yes or no. Let's continue.
That is pursuant to OCGA 17-10-1, subsection 2, A2A. And Mr. Steele and Mr. Adams, in order to keep him on reporting status, there needs to be good cause shown. We all concede that good cause is shown here?
Stipulate.
All right, I appreciate that. Special conditions of your probation.
What good cause? What do they mean?
Can I have a second?
Mr. Steele is going to confirm with his client what good cause means to show that he should be on reporting status. And that's really that he was facing a substantial amount more time and was given a substantial amount less time to be on probation. And that's why he needs to be reporting. So that's why the attorney stipulated. And then we'll get into what the special conditions are that this judge ordered.
After 48 hours from your release, you are to stay away from the metro Atlanta area. And that's defined by the U.S. Census Bureau.
The first term of probation is to stay away from Metro Atlanta, the entirety of Metro Atlanta. She's going to make some exceptions to this, but that is a very, very broad swath. They were asking to stay away from the location where they were alleging that the YSL gang was operating out of. She took that much larger to the entirety of Metro Atlanta.
May change. But you can look that up anytime to figure out what that is. For the first 10 years of your probation, subject to the following exceptions, you are permitted to be in the metro Atlanta area to attend any wedding, funeral, or graduation from high school, college, or graduate school of any of your immediate family members. And immediate family members is defined the same way that you all were contemplating it when you were negotiating.
Brian Steele did not look happy with the entirety of Metro Atlanta.
You can get here up to 24 hours prior to any such event, and you need to leave within 48 hours after any such event. In addition, during each year of your probation, I'm going to require that you come to the Metro Atlanta area and make a live anti-gang and anti-gun violence presentation 4 times a year each year of your probation at a grade school, a middle school, a boys or girls club, anything like that.
Your Honor, he is famous. Have you thought through how difficult this is going to be? And also maybe juvenile detention facilities. But stay away from Metro Atlanta. But 4 times a year, come back to Metro Atlanta and make anti-gang presentations at schools. So there is going to be also a required travel back to Metro Atlanta for the first number of years of his probation.
Type of group. And if you want to, that presentation can include a benefit concert, and these presentations may count towards your required community service hours, which I'm going to impose, that during each year of your probation, you perform 100 hours of community service.
During each year of probation. Each year of probation, 100 hours of community service. It is quite a lot of community service, though it does seem that the presentations will count as community service, but that is a lot of community service for a long probation. That is 15 years of probation.
You are, and this is required by the fact that there's a gang conviction. You shall not knowingly have contact of any kind or character with any other member or associate of any criminal street gang. Exception to that, if your brother is a member of any street gang, I hope you talk him into getting out of it. Quantavious Greer, and then also Sergio Kitchens, as long as you are contractually obligated to him. That is going to include anybody who is named in this indictment.
So there are some carve outs for his brother and Sergio Kitchens, as long as he and Kitchens have a contractual obligation to one another and they are doing business deals together. So there are carve outs to the, you may not have any interaction with any member or associate of a criminal street gang. Those are standard conditions for gang cases, but then those carve outs. This carve out, though, is kind of vague, given that if he is continuing to perform, what does that mean? Everybody? So I think there are going to be some communications back and forth with probation as this goes forward about what if he goes to an awards show? How does he know who might be on somebody's security detail or entourage or what have you? There's a lot of potential pitfalls in this that he might not have control of. So I think there's going to be a lot of conversations with probation about this particular term of probation.
Except as absolutely necessary to conduct the lawful business of your musical career, and to any extent that the state is not agreeing to the exception for Mr. Kitchens. In the event that that part is not enforceable because it is only a portion of a special condition, going to provide that that be severable from the rest of this, and I'll put some case sites in the Senate sheet for that. You are in no way to promote any criminal street gang or any criminal street gang activity, including on any social media platform. You are not to utilize any hand signs, terminology, or language that promotes any criminal street gang. You are not to participate in any criminal street gang activity.
And again, you can see how broad this language is of hand signs, terminologies, language that promotes or represents criminal street gang activity. They used a lot of his music in this trial, or tried to. So does that mean he can use his old music, not use his old music? What are they considering represents any street gang, and where are the boundaries to that? Again, I think it's going to be something that they are going to have conversations with probation about going forward.
You are not to knowingly engage in any contact with any of the victims that are listed in this indictment, or with any of their family members. And you may not have in your possession or with arm's reach any kind of a firearm because you're going to be a convicted felon. And that is, except I know that you have security and you need security. You can be within arm's reach of a firearm that is in the possession of either licensed law enforcement or licensed security personnel that are in your security detail. Or
He's going to have to vet his security detail incredibly well moving forward.
Anybody that you're performing with.
And who he's performing
are to
with,
submit to
and
random drug
their
screen.
entourages, and their security details, because somebody he's performing with could get him into shit based on the terms of his probation. It says knowingly, but also we've seen how far the state has reached in this case. So he is going to have to be incredibly careful with these terms of probation.
And not use any drugs unless they are prescribed for you by a licensed physician. You are to execute a Fourth Amendment waiver that will permit the search of your person, residence, vehicles, and
These are common terms
electronics
of
for
probation.
any firearms, any criminal street gang paraphernalia, or any illicit drugs.
And that gets to the end of the terms of probation. The last terms were standard. He will be a convicted felon, no firearms, no illegal narcotics, no drugs of any kind unless prescribed. He did say he had a place in California. So if he goes to California and gets a prescription for marijuana, even though it's legal in California, would that be a violation? Probably not. But these are questions they're going to have to ask probation for. He's going to have to submit to search and seizure conditions, which means they can search at any time. They can require drug tests at any time. And when we talk about those Fourth Amendment waivers, that includes searching devices, cell phones, electronics, searching cars, searching for firearms, and all of it. And lots of you probably want to know, what does that mean for his prior songs? Well, he is probably going to have to go through with his lawyer and probation and possibly make a motion to the court to have songs either allowed or disallowed, because if the court finds that those songs have lyrics that promote gang activity, then he's not going to be able to perform those songs because it would violate the terms of his probation. So he has Brian Steele, who we have seen is a very passionate advocate, who's going to want to go through this with a fine-tooth comb. Brian Steele is going to be focused on making sure that there is nothing the state can use to try to drag Young Thug back into court to violate his probation, because there is a term of confinement that is hanging over his head. Probation violations are much easier to prove. There's no jury trial. You come in, okay, did you sing a song that the court believes promoted gang lyrics? Yes. If that happens, then he gets the rest of that backloaded sentence, which is 20 years. So he has to be incredibly careful. And that is something he and his lawyer are going to have to work through. In addition to the community service hours and the talks that he has to give, the court also issued up to $40,000 in fines on these sentences. So at the end of the day, we have 2 no-low pleas on counts 1 and 56, and then guilty pleas on counts 57, 58, 59, 60, 61, and 62, with a total sentence of 40 years, with 5 years in prison commuted or changed to time served, 15 years probation, with 20 years backloaded or suspended, meaning if he violates probation in those 15 years on those conditions, then the 20 years is what his sentence will be. If he violates probation, then 20 years in prison. So I've gotten a lot of questions about whether or not probation that long feels like a trap. You're going to have to let me know what you think in the comments down below. He wanted to get out of custody. Sometimes getting out of custody with a probation that long, with 20 years hanging over your head, is not always an easy thing to do. Because if there are any violations, then he will get 20 years. And I can see where his attorney is frustrated, especially with watching how inartfully this case has been tried. I don't know how much the jury is going to even remember about this case and whether or not he would have been acquitted. And if these two other defendants go forward for the rest of trial and get acquitted, Young Thug is still going to have that 20-year suspended sentence hanging over that 15 years of probation. You can understand both why he wants to get out of custody and why his attorney wants to ride out the next few months of this trial and hope for an acquittal. I can understand Brian Steele's frustration here, and we've seen it in his media interviews, but at the end of the day, it is the client's decision, and he wanted out of custody, and that is what he got. But will this end up being a good thing, or will it end up being a slower walk into 20 years? Only time will tell, but I'm sure that the prosecutor's office will be keeping an eye on what Jeffery Williams is up to. However, he is a successful musician. He does have the ability to have someone like Brian Steele on retainer and be able to run everything he does by Brian Steele. He will have to be incredibly vigilant with that, and we will see how it goes. And with that, we have to talk about somebody else who probably wants to be out of custody. I know you've heard me talking about upgrades coming to the Law & Nerd shop, and because of today's sponsor, Shopify, it's never been easier. What I love is that Shopify has been with me since the very beginning of the Law & Nerd shop and growing to the Law & Nerd shop version 2.0 that I can't wait to unveil this month, but it's still powered by Shopify. Why? Because they've got you at every stage of business, from just getting up and running to taking it to the next level. Shopify has the #1 checkout on the planet, so it makes it easy for your customers to become buyers, which means less abandoned carts, more sales, and Shop Pay really helps make it easy for people to shop your store on Shopify. So whether you're just starting or you're growing your business to the next level, your commerce platform better be ready to sell wherever your customers are on the web, because businesses that sell more sell on Shopify. So if you are ready to upgrade your business and get the same checkout that we use for the Law & Nerd shop, you can sign up for your $1 per month trial period at shopify.com/lawnerd. Remember, that's all lowercase. Go to shopify.com/lawnerd and upgrade your selling today. Shopify.com/lawnerd, and you'll be hearing this sound soon. Let's get back to today's episode. And we're going to talk a little bit about Diddy. Diddy's lawyers are so pissed, and it's about what I talked about on Quick Bits. I mean, it's not about me. Emily, isn't it always? No, this isn't about me. Diddy's lawyers are so mad that the witness from the grand jury is talking to the media and that the attorneys for the witness from the grand jury are talking to the media. If you do not listen to the Monday episodes, y'all are missing out, because we spilled the tea on Monday and Diddy's lawyers filed today, also Monday, but you're listening to this on Wednesday, but also Monday. Diddy's lawyers filed today about that. Let's do a quick recap of what's pending, and then I'm going to do a summary of why Diddy's lawyers are so incredibly mad. And it seems that the court is at least a little bit concerned. So there are multiple motions pending in court that were supposed to come before the court for hearing on December 18th. I think that's going to get bumped forward. Diddy's lawyers weren't required to respond to the motions from the prosecution until later in November, but are like, emergency, we have to talk about what's going on with the grand jury. And now we all know that the grand jury's ongoing. I mean, grand juries can be ongoing, but knowing that this grand jury indicted Diddy and is still looking for more was illuminating. So these are the pending motions. There is a request for hearing, and that initial request for hearing was the defense alleging that the government was leaking everything. Your Honor, the government leaked this video from the hotel to CNN, and DHS is doing this, and everyone is leaking stuff, and it has to stop. That was the first motion. The second motion is for a bill of particulars. The defense is saying to the court, make them identify all of their victims in a more particular indictment. And then their third motion is for a gag order. The original motion was for any extrajudicial statements from prospective witnesses or their lawyers. And this has popped off because now the defense is super upset that the witness to the grand jury has spoken to the media while these motions were pending. So they want nobody to talk about anything. They want everybody's name out there, and they want the court, well, in a very, very big reach, they would like the court to prohibit the government from using that tape of Diddy assaulting Cassie in the hallway of the Intercontinental Hotel. You can see how angry they are about that video because they're like, well, Your Honor, the government leaked it. It should be suppressed. That's not going to happen. And the government has said repeatedly in motions, and now we know in emails because they attached them to their motions to the defense, we didn't leak it. CNN put it out there, and we then got it after CNN put it out there. This wasn't leaked from grand jury proceedings. This wasn't leaked from anyone. The media got a hold of this, and we don't know how. And I speculate, which I do rarely, but I speculate that based on the allegations in this indictment that include allegations that someone paid off the Intercontinental Hotel to make that security footage disappear, Diddy is telling his lawyers, and again, this is my speculation, Diddy is telling his lawyers, we got that tape. How the fuck does it still exist? How is there any evidence of this? So Diddy is alleging that the government is the one leaking it and therefore it should be suppressed. Now, notice they're not losing their mind over CNN. Well, it's because CNN's going to say, we don't have to tell you anything, free media. And if CNN did give it to the government, then the government didn't leak it. And then they don't really have much of an argument for suppression, which seems to be what they want. They don't want the government using that video in trial. And for any of you that have seen that video, you can understand why. I think many who saw it probably had a visceral response to seeing it. Diddy is readily identifiable in that video. And no matter what they say in court about it, it speaks for itself. And if you watch the Sarah Boone case with me, you know how powerful video can be in cases like this. And I think that's why the defense is raising all alarms over this latest witness that's coming forward from the grand jury saying, I've got a bunch of video. So we're going to see what the defense said, but I'm going to ask for a difficult task. And you're like, Emily, it's Wednesday? We're post-election. Please don't ask us to have intellectual flexibility at the moment. We're tired. I get it. But assuming this isn't Diddy, there is some room for argument about how much pretrial publicity is too much pretrial publicity. And we can always have this conversation another day too. Just pause, come back tomorrow. I'm teasing. Don't finish the episode. It's great. I say that optimistically as we're still recording. But how much pretrial publicity becomes too much pretrial publicity? We saw quite a lot of arguments from Brian Koberger's defense team in Idaho about this. At what point is the jury pool too saturated to put this out of their mind? And is there room for the defense to rightfully argue here that if everybody keeps coming forward to the media, that this man can never get the fair trial that the Constitution guarantees him? And when is too much too much? And the prosecution, when they respond to this, and we'll see what they have to say, the court gave them till Tuesday morning. Are they going to say, we can't control everyone who's called before the grand jury? Grand juries are supposed to be secretive. So could the government tell witnesses to the grand jury, you cannot speak about the evidence you gave to a grand jury at this point? Yes, I think there is some room for them to say that. But if those witnesses also are pursuing civil lawsuits, can you restrain civil plaintiffs from saying, we are also suing Diddy over things? And I think that potentially goes too far. So there are some really more nuanced conversations about how much pretrial publicity is too much, how much is a prior restraint on speech that cannot be restrained, and can a criminal court try to restrain what civil plaintiffs are doing in civil litigation? At what point is it too much? I mean, I guess the other side of at what point is it too much is the question, is the shit already out of the horse? And whatever they do now, it doesn't really matter because the shit's already out of the horse. Like, are we just Is it just so bad that we're done, really, with Diddy? Because the media is not going to stop covering this. And I know that when things go on in court for me, that you guys reach out and are asking what's happening and are looking for what does it mean. There is an incredible amount of interest in this case because it seems to feel like it's been a long time coming. What we are looking at is the defense filing from November 3rd, and I think a little bit of their impact and snark is lost if we don't just read some of their words, because again, they are big mad. Big mad. So this is to the judge, November 3rd, 2024. We write on behalf of our client, Mr. Sean Combs, regarding the deluge of improper pretrial publicity that is undermining Combs' right to a fair trial and the integrity of the grand jury proceedings. As the court is aware, Mr. Combs filed a motion with respect to extrajudicial statements by potential witnesses and their counsel, that is docket number 42, which the government has opposed. They did. And the government opposition was, Your Honor, it's premature to disclose every single witness, and you can't use a local criminal rule to put a gag order on civil claimants, and what they're asking for is way too broad. That's what the government said in response. They're going on to say, however, given the imminent harm of certain extrajudicial statements relating to the ongoing grand jury proceedings, so we know it's happening. The grand jury is the grand jury is the grand jury. We request that the court immediately restrain extrajudicial statements by potential witnesses and their counsel during the pendency of the motion. Over the past several days, a grand jury witness and his attorney have given multiple interviews, including outside the courthouse immediately following his apparent grand jury testimony. Spill the tea, defense. Let's hear it. Let's just hear it. What are you saying that they said? What are you mad about? Because it's going to just continue to direct my attention to what I should be looking for. They say that this witness is making, quote, false and outrageous claims, including that the witness possesses videos of Combs involved in the sexual assault of celebrities and minors. Footnote 1, that seems to be a TMZ article and or video, the title of which is Diddy Grand Jury Subpoenas New Witness Claims to Have Tapes and Kim Porter Diary. Well, can we see why the internet wants to know everything? It goes on to say that the subpoena comes on the heels of his attorney's statement that she had been asked to, quote, shop a particular video and contact a celebrity, quote, in the video to see if they were interested in purchasing the video before it became public knowledge. I don't know if that's true or not, but they linked to a News Nation video that is titled Diddy Accuser's Lawyer, High Profile Person Unknowingly Recorded. That's from September 27th, 2024. So these statements have been out there for a minute, but when you get to trial, shopping a video doesn't always look great if you are the witness. But then again, if the witness is like, somebody gave these things to me, I don't know. I just wanted to know if somebody didn't want them to see the light of day. Oh boy. It goes on to say, in anticipation of his testimony, the witness's lawyer made numerous statements to the media about his testimony, including that the government had subpoenaed him to testify about the alleged videos. Footnote 3, that is a CNN article titled Grand Jury in Sean Diddy Combs Case Hears from Witness Who Claims He Has Footage of Combs Potentially Victimizing Celebrities. That broke on Halloween. And then they cited another article from NBC on October 30th, New York Grand Jury hearing new evidence in Sean Diddy Combs federal case. Well, that is the mildest of the headlines. Thanks, NBC. We appreciate a headline that is just what it is. We love it. It goes on to say immediately after his appearance at the grand jury, he and his lawyer were interviewed on the courthouse steps. Like this defense attorney was immediately after Diddy's arraignment. But I digress. Saying that evening, they also sat down for an interview where the witness claimed he had seen videos of 8 celebrities being victimized, including some who appeared to be minors, and all of whom appeared intoxicated. Footnote 5. And that comes from a TMZ article and video. It says these stories have spread rapidly through the media and created the impression that such videos exist. They say in their motion, which is false. and that the government is actually crediting his sensational claims, which is profoundly prejudicial. I don't think the judge is going to like this at all. I don't think the judge is going to like a grand jury witness saying, this is what I told the grand jury. I think the judge is going to be mad about this. And the defense is saying, no, those videos don't exist, because they're putting it in a court document saying, no, those videos don't exist. Those videos don't exist. Well, do they or don't they? Because we know how much recording was taken out of all of these homes. So maybe what they're contending is that this witness actually does not have them, but they are mad. It goes on to say, while the witness and his attorney eagerly spread false and unchecked claims in the media, they have avoided subjecting their claims to verification through the legal process. They say, for instance, the witness and his lawyer admit that he resisted complying with the grand jury subpoena and only appeared after the marshals tracked him down, footnote 6 from the same TMZ article. And when directly asked if they had videos to back up their outlandish claims, the attorney responded, that's what we're going to head over to do now. So we're having a hearing to determine what we're going to do in terms of what documents we will have to turn over and what documents we do not. Footnote 7. Her references to quote unquote documents rather than videos is a clear indication that they do not, that was in a typo in the motion, do not possess the latter. Indeed, this witness, who has never even met Mr. Combs, footnote 8, claims that he received the tapes from an unknown individual who was supposedly shot and killed, along with the purported memoir of the deceased mother of Mr. Combs's children that has since been denounced as fake. I think that mischaracterizes things a little bit, because he says he has Kim Porter's diary, which I think is different than the book that somebody put out on Amazon that was in fact fake. It goes on to say, by treating these ridiculous claims as anything but a pathetic extortion scheme, the government is fueling the fire of online conspiracy theories and making it impossible for Mr. Combs to have a fair trial. Sir, what in the world did the government do in any of this? This is a witness who didn't want to testify, it seems, and their lawyer who were quote unquote shopping a tape. But I don't know what the government had to do except say, we heard this existed. You're coming before the grand jury and getting questioned under oath. What else did they do? It goes on to say the government's main objection to the extension of a gag order to all civil litigants is that it would be extraordinary and beyond the purview of the local rule. Based on this assertion, which is unsupported by any legal authority and ignores the rule's facial applicability to lawyers for grand jury witnesses and the witnesses themselves, the government suggests that the issue should be litigated piecemeal in courts throughout the country. The government is inviting error. This court has an affirmative constitutional duty to minimize the effects of prejudicial pretrial publicity, and the measures a judge takes or fails to take to mitigate the effects of pretrial publicity may well determine whether the defendant receives a trial consistent with the requirements of due process. They go on to continue to cite law that supports that argument for them, or that they argue supports that argument with them. They go on to close with, moreover, it makes little sense that civil litigants seeking to capitalize on the criminal allegations against Mr. Combs can nevertheless claim that they are not involved in the criminal proceedings for the purposes of the local rule. Those litigants and their counsel stand to financially benefit from a conviction and therefore are highly motivated to make damaging statements to the press. To say that those cases and litigants are unrelated is illusory. They then go on to cite a New York Post article published October 31st, and they say that the New York Post attributed the following to a, quote, federal law enforcement source who is involved in the investigation. And these are their bullet points of what they're mad about a federal law enforcement source allegedly saying. Quote, they're all too happy to talk, says a federal law enforcement source who is involved in the investigation. We're asking them about their recollections of the freak-offs, what they were paid to do, and who else was involved. I'm surprised how many of them can recall intricate details about what happened. The source told the Post that many of the men who were in their 20s at the time of the parties are now in their 40s and have aged out of they say the Skin Biz, and have offered similar details about the parties. They say that they were encouraged to take Viagra and Cialis before the parties, that they were expected to perform and were told if they didn't perform, they'd be thrown out of the party and not paid. They say that authorities were trying to determine if any of the participants in the freak-offs were underage or illegally coerced. They say we have to identify all the people in the videos, said the Fed source, and then we can figure out how old they were at the time and make sure none of them were trafficked or threatened to participate. It's a long process, but we're making progress. Footnote 11, which links back to an article from the New York Post titled "Diddy Investigators Have Interviewed Male Escorts About His Infamous Freak-Off Parties, and they're, quote, happy to talk," says a source. They say that the government has been investigating for nearly a year, and as they are aware, their own allegations about the freak-offs do not relate to men at parties or alleged underage victims. In light of the continuing prejudicial extrajudicial statements by witnesses and their lawyers, and the extent to which these press statements generate further government leaks, we respectfully request the court enter the attached proposed temporary order restraining speech of potential witnesses and their counsel from the defense. And this is in addition to the court's already fairly sternly worded, hey, everybody, remember, you're professionals and you're not allowed to leak grand jury information. So I wonder how concerned the court is, or at least somewhat perturbed, because the court responded with this. And the court stamped their notes on the docket item saying, quote, given the urgency of the issue, if defendant has additional arguments to make on the motion at docket 42 in reply to the government's opposition, he should provide those to the court by November 5th, 2024 at 12 p.m. So ordered. And that was on November 4th. So Diddy wasn't required to file their response or reply to the government's opposition yet. And the court said, we're going to move this forward. So if you have anything else to say, you need to tell me because we're going to move this forward. So I think the court is probably going to put this on calendar potentially this week instead of waiting till that December 18th hearing. And the court is clearly taking this seriously given the urgency. So the court has also, again, made statements reminding everybody that leaks are improper and that leaks of law enforcement can be held against the government. I'm very curious to see what the court is going to do here. Let me know what you think the court is going to do in this case. And if you think that this is becoming a problem, are we too far past this being a problem? And where are the boundaries of free speech and pretrial publicity as it relates to the civil plaintiffs, as it relates to potential grand jury witnesses who are restrained in some other ways or can be because the grand jury proceedings are secretive? Where are the boundaries here on what people are allowed to share and what they're not, and how that bumps up against the defendant's constitutional rights? Law Nerds, I would love to hear what you think. It's going to be a busy week. We have lots to talk about in Karen Reed, plus her attorneys are going to oral argument before the Supreme Judicial Court in Massachusetts, and we have to get into some music lawsuits for a little bit of a lighter note. And if you missed a little bit of a lighter note last week from Food Court, make sure to check it out, because sometimes we just need to talk about a cheeky donut spider who wants to talk about your girl saying that they're not so itsy bitsy, or, you know, what is and is not the proper shape of a Reese's. So if you need to look for that, it's going to be linked below or on YouTube, recommended. So with that, Law Nerds, thank you for being here. Thank you for being a Law Nerd. Don't forget, if you head over to Law Nerd Shop, you can get your Law Nerd tumblers right now before they go away forever. So if you've been holding out on our amazing iridescent tumblers, last chance before they are gone over at lawnerdshop.com before we unveil the new Law Nerd Shop 2.0 later this month. I have lots of exciting announcements for you next week. So with that, may your families be well. May your Wi-Fi be strong. May your family be well. May your toilet paper be plentiful, and maybe your Reese's too. May your Halloween candy still be giving, and may the odds be ever in your favor. Thank you for being here. Thank you for being a Law Nerd. I'll see you in the next one. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com or search your app store for Law Nerd. And you can also follow me on social media at The Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, The Emily Show drops on Wednesdays. Thanks for being a Law Nerd.